Hello everyone. In this video we are gonna see about ADR, Alternative Dispute Resolution Mechanism, and we'll see about ADR in India and the issues regarding ADR mechanism in India and what are all the steps can be taken to make India an arbitration hub. This ADR, Alternative Dispute Resolution, is an array of methods for resolving legal disputes without resorting to the court systems. So, this ADR is a mechanism of dispute resolution that is non adversarial, that is working together cooperatively to reach the best resolution for everyone, and it is aimed at dispute resolution settlement outside the court, and it offers to resolve all types of matters like including civil, commercial, industrial and family and all. And this ADR can be instrumental in reducing the burden of litigation on courts, while delivering a well-rounded and satisfying experience for parties involved. And also it provides the opportunity to expand the pie through creative, collaborative bargaining, and fulfill the interest which driving their demands. And in general, it plays a pivotal role in the American legal crisis, but it is often overshadowed by the jury trials. When we might have imagined all the legal disputes are there and there, right? So in large courtrooms, it filled with jurors, inspectors, where in reality, only 5% of civil cases ever make it to trial, and in some states the number has reached as low as 0.2% also. So the same is that for criminal cases it is only 10% that reach the trial. The other 90 to 99.8% of legal disputes are resolved through some forms of ADR, and this ADR method have gained a substantial traction over the past 30 years, and they are increasing the popularity of clients, attorneys, and judges alike. And there are four primary reasons for this rise in popularity. First of all, ADR increases the court efficiency, and the general public also there has never been more litigious, and there are only some judges available to handle the ever increasing cases. As a result of that, only many judges now issue score or requiring the parties to engage in some forms of alternative dispute resolution before allowing a case to proceed to trial. And the second reason is that this area is less costly than a trial. So this trial is by far the most expensive stage of litigation, and it often involves the additional expenses of expert witnesses, and most plaintiffs attorneys pay a contingency fee, so that significantly increases the case reaches the trial stage, and the attorneys often spend well over half of their billable hours in trial or in trial preparation. At the end of days, the clients are generally happy to avoid these trial related expenses. And the third reason is error is less risky than a trial. And a trial, a judge or a jury decides the case which may lead to an unintended outcomes, and the trial offers no guarantee of a fair or favorable decision. Most forms of error reduces the amount of risk the parties undertake, by leaving the outcome entirely in their hands. Finally, as the ADR proceedings are quite preview, and the proceedings court proceedings open to the public, and by the virtue of their advisory nature, litigation tends to flash out the cherished secrets of embracing facts and allegations, and unfortunately to the parties, the media can resist news of the information, and which usually ends up making headlines. But the parties who are engaged in ADR in order to keep their reputations and trade secrets in case intact, they work towards their resolution. So this is the general introduction of ADR, and obviously the advantages of ADR. First one is like it facilitates parties to deal with the underlying issues and disputes in a more cost-effective manner and with increased efficacy. And in addition to that, these processes have the advantage of providing parties with the opportunity to reduce hostility, regain a sense of control, and gain acceptance of the outcome with a greater sense of justice. And next is the resolution of dispute takes place usually in private and is more viable, economic, and efficient. And also it is more flexible and it avoids seeking recourse through the courts. It has been seen that resolution of disputes is quicker through ADR, and this often results in creative solutions, sustainable outcomes, and greater satisfactions and improved relationships also. And the possibility of ensuring the specialized expertise is available in the tribunal over time in the patients like of arbiter, mediator, conciliator, or neutral advisor. And this ADR has proven successful in clearing the backlog of cases in various levels of the judiciary, and the local adult alone have disposed of more than 50 lakh cases every year on average, and it is in the last 3 years. So these are all the advantages of ADR, and now we'll see the ADR mechanism in India. In India, the number of cases filed in the courts has shown a tremendous increase in recent years, which is resulting in pendency and delays, and it is underlying the need for the alternative dispute resolution methods. And the Legal Service Authority Act was passed in 1987. It was passed to encourage out of court settlements, and also the Arbitration and Conciliation Act was also enacted in 1996 for that. And the procedure for bargaining was included in the Code of Criminal Procedure in 2005, and this plea trial negotiation between the accused and the prosecution, during which the accused agrees to plead guilty in exchange for certain concessions by the prosecution. And the loc adolet, which is the people's court, it comprises an informal setting which facilitates negotiations in the presence of judicial officer, and wherein cases are dispensed without undue emphasis on the legal technicalities. The order of the Lok Adalat is final and it's binding on the parties, and it is not appealable in a court of law. And in 2015, Arbitration and Cancellation Amendment Act was enacted to improve the arbitration in India, and the Law Commission in its 129th report and Malamat Committee, they recommended making it mandatory for the courts to refer disputes for resolutions through alternate means rather than the litigation. And the Arbitration and Conciliation Amendment Act in 2019, it seeks to establish an independent body called the Arbitration Council of India, and it is for the promotion of alternative dispute resolution mechanisms. And the New Delhi International Arbitration Center Act 2019 was enacted with a view to provide for the establishment and incorporation of the New Delhi International Arbitration Center. And its objective is to create an independent and autonomous regime for institutionalized arbitration, and to make it a hub for institutional arbitration, and to declare the New Delhi International Arbitration Center to be an institution of national importance. And these are all about ADR in India. And now we'll see the issues regarding ADR mechanism in India. One of the major issues is due to which the arbitration is not growing is growing, which is not growing in India, is because of lack of awareness among the people. And most of the people are ignorant towards arbitration, and they still trust the courts more than the alternate dispute resolution. And the arbitration in India is rampant with delays that hamper the efficient dispensation of dispute resolutions. So, in the ground realities shows that arbitration in India, and particularly that ADHO's arbitration, it is becoming quite expensive in comparison with the traditional litigation. And it is also because of lack of more comprehensive laws regarding arbitration process and proceedings. This point also add to this problem. And the intervention of court, most importantly in arbitration proceedings also, it also results in inclination towards the courts. Yeah. And so these are the issues regarding ADR mechanism in India. And now we'll see the steps to make India an arbitration hub. It is essential to promote arbitration and thereby prevent the private players from rushing to the courts without resorting to the relevant provisions of arbitration in the contract. And the national and state legal service authorities should disseminate more information regarding this ADR mechanisms, so that they become the first option explored by potential litigants. And the institutional arbitration becomes mandatory now if uh, becomes mandatory if India wants to have a robust domestic arbitration environment. And also, if court intervene in ADR proceedings, now the whole purpose of ADR is defeated. Minimum of judicial interference will go a long way in strengthening the ADR mechanism. And the arbitration laws are required to be amended on a regular basis, and they're crucial to improve the conditions of the arbitration in India. Before concluding, I can say that every country they aspire to become the center of arbitration for owing to various benefits. Okay, so and also every country wants to get more and more investment, but the investors take a note of various factors before investing in a country. Like they'll see that whether the country has a robust arbitration mechanism, and whether the codes and government of that country are arbitration friendly, and whether there is ease of doing business and a stable environment and all. They'll see that. Okay, so in India, our government has taken certain steps to make India a hub of arbitration. In the Arbitration and Conciliation Act 2019, under section 43 A to 43 M, it provides for establishment and Arbitration Council of India. But these the provided steps in that, it is not sufficient. And so India can achieve its dreams of becoming a hub of arbitration if some issues are addressed. Some of that issues are in India. Most of the arbitrations are ADHOC, and we are slowly moving towards institutional arbitrations. And the lawyers, they often give second preference to arbitration matters. Those lawyers, after they spend the whole entire day in court, they are already exhausted, right? And so the in arbitration, the proceedings do not go on for long. And so some arbitrators who are also practicing in the courts are unable to give sufficient time to the arbitration proceedings. So there is a need of full time arbitration lawyers and arbitrators who devote sufficient time to arbitration, so that there are no delays in the arbitration proceedings, right? So we need a full time arbitration lawyers and arbitrators. This is the first issue. And next is the lack of proper law regarding arbitration proceedings. The government has recently brought in amendments, and after that amendments, it shows that issues were not properly addressed, and the amendments was not properly drafted. So the second issue is that lack of proper law regarding arbitration proceedings. And next is lack of institutional arbitration. Owing to the busy schedule of litigation lawyers in India, it is unlikely that any leading lawyer would thoroughly engage with an arbitration center. So there is a lack of institutional arbitration. And next is judicial intervention. Other issue is uh, it is there is inadequate support from court. So the other problem is that some of the judgments uh, decided by high court have turned out to be some like a bad jurisprudence. For example, in the case of ONGC versus Saw Pipes Limited, it so like these cases, it takes years to undo the harm which judgments like these judgments and all cause. So these and all, they form a perception of India, perception that like India's jurisdiction which is not arbitration friendly, where investments and all not safe, like that it forms perception because of some cases like these. And also judicial intervention, like it is there is a inadequate support from court. And next issue is that practice of appointment of retired judges as arbitrators. We do not let young arbitration lawyers be appointed as arbitrators, and as a result of that only, the mostly the retired judges are appointed. So this practice must be done away. Young lawyers must be appointed as arbitrators in disputes. This will make the arbitration mechanism more robust as a whole, and the quality of awards will also not suffer. Okay, so yeah, no other country is thus fond of appointing only retired judges as arbitrators like ours, like our country. So we should see to it. Young lawyers also must be appointed as arbitrators. And next is the arbitration proceedings in India from other difficulties also, such as absence of professionalism and mannerism. Arbitrators they do not have dates for proceedings for months, so that leads to unnecessary delays and all. So yeah, the government interference should be least in arbitration matters. And and the most important thing is that there is a lack of awareness. So in the general public, there is a lack of awareness about choosing arbitration over litigation. So more awareness campaigns should be introduced to educate the society at large. And the students, the practitioners, and other members of the legal fraternity, they should be trained and they should be encouraged to step in full time arbitration lawyers. And also, less judicial information interference is definitely required. We like, if these issues and all addressed na, India can achieve its dream of becoming a hub of arbitration. So yeah, these are all the steps that should be taken to make India an arbitration hub. So I conclude here. Thank you so much.